Good morning, everyone, and welcome to this morning's webinar on mortgage repossession in Queensland. Before we begin, can I just acknowledge, in addition to the slide we have up, that it's NAIDOC Week and the important role that our First Nations people play both in society and in improving outcomes for all of us in the legal system. My name is Paul Holmes and I'm a principal lawyer in the Civil Justice Services area of Legal Aid Queensland. And with me today is my colleague Loretta Crete, who is our Acting Assistant Director in Civil Justice Services. I'll quickly run through some housekeeping before we get into today's topic. This webinar will be recorded and displayed on YouTube after the webinar. If you have any technical difficulties in accessing the webinar, can I encourage you to go to the GoToWebinar support page. The webinar will run for approximately 1 hour. There will be a Q&A at the end. However, we welcome you sending through any questions you have as we're going, because Loretta and I both are happy to answer questions as we go.
We like questions.
Absolutely. The more questions, the merrier. You will also see that in your options, there is an option to download the slides in the handout section of the screen. You are welcome to do that. If you have a question, please input that into the question part of that screen. Now, in starting today's session, we always find it's good to start with some polls just to get you interacting with us and encouraging you to ask this question. So the first one I'm going to launch. So we just want an idea of where you are and where you're viewing us from. You can see we've got a lot today from Southeast Queensland, a fair number from Far North Queensland, a good number from regional Queensland, and a good percentage still from outside Queensland, which is great. Just a reminder to those people logging in from outside Queensland that we will, when we're talking about the court proceedings around mortgage repossession, that will be specifically related to Queensland. There will be obvious similarities between Queensland and other states, but you should check with legal services in your own state about the specific court-related procedures that might apply to you.
And can I just give you an example? Because whilst we might do that when we get to that.
Yeah, absolutely.
Part of the presentation when we start to talk about those differences.
So I've just briefly shared those poll results with you and shows a good mix of people here. So our second poll, is around what area do you work in? And I'll get you to respond to that now. I've got a good number of financial counsellors on the line, which is great. A good number of community workers and education workers, and a good number of others. If you're feeling brave and want to share with us in the question box what other roles you perform, Loretta and I are always interested in the sort of people that are interested in our webinars. So I'll just close that poll now and just quickly share that with you. It shows most of us are financial counsellors today, but welcome to everybody else, and we hope you find it valuable. And our final poll, just quickly, what experience is essentially around what experience you have about mortgage repossession. And I'm expecting a full range here. We're going to have people that know a lot, people that know a little bit, and people that know nothing at all. And all of those are okay, and feel free to ask any level of question you like, because the only way you find out about stuff is if you ask it and seek help.
And in fact, Paul, I've always found that no question is a silly question, because often people have said, oh, this sounds like a really easy question. You know, maybe it's too easy. And I've gone, oh, I hadn't thought of it that way. Or it's said, I've often had to say, well, that's not an easy question at all. So.
No, and the thing about it is if you don't know the answer, it's not a silly question, and it's not an easy question.
No, exactly.
All right, so we might get into the meat of the session today.
Yes.
So mortgage repossession following financial hardship. And what we want you to take away from this, hopefully, is some new knowledge about how the process works, when to refer to us lawyers, and how best to help your clients. So we've been through all these slides. All right, let's start. All right.
All right. So exactly what you learned today, what lenders need to do before they start enforcement and take repossession of the property, the repossession process in Queensland. And this is where I do want to stress it is about Queensland. So even though we talk about the National Consumer Credit Protection Act as being the act under which the loans were given, the repossession process, or to be able to take action in the courts, is a state process. So not only does the lender have to comply with the processes under the National Consumer Credit Protection Act, or the National Credit Code, but they also have to comply with the Property Law Act in Queensland and the Uniform Civil Procedure Rules in Queensland as well. So that's why we think that this session may be more appropriate just for people within Queensland. But what you can do to prevent repossession of your home, well, obviously a lot of that will apply nationally. And what happens after repossession, which would be very
apply nationally.
Will apply nationally. Yeah.
All right. Next slide.
So this we're just going to talk briefly about, and we'll talk about each of the it's separate, but basically the repossession process in Queensland follows these steps. There's a default, there's a notice, so we didn't put that in. There's a notice given to the borrower that requires them to pay, and that notice and we'll talk about that in a little while. So, and then a claim is filed by the lender in the court, and it has to be served on the borrower. If no defence is lodged by the borrower, then the lender can get default judgment. We talk about how that judgment is served.
Yep.
How that judgment is enforced through the enforcement warrant, and what happens, how a person can be evicted from their property and the processes around that. We also talk on each of those steps what you might do to prevent that occurring. Okay, next, Paul.
All right, so let's talk about defaults. So when we're talking about defaults, I kind of want to briefly talk about just before we get to defaults, because sometimes you'll get clients who are behind but haven't got the default notice yet.
Yes.
And it's really important, if you get a client like that, as financial counsellors would know very well, that you talk to the lender as soon as you can, because if you can even prevent the default process from being issued at all, that's usually a win for the client.
It really is. And people get quite panicked about, they're behind, and you can reassure them, well, you haven't even been served with a default notice, so they can't do anything at this stage against you. So I think it's certainly something that's good to have a discussion with your client as to the first thing that you need to find out is where they are in that process.
So I'm just checking. I've got a couple of messages saying we can't see you guys. Can I just check that everybody can see us on the video? Good now? Excellent. Okay, great.
Because I wouldn't like it if they couldn't see me, Paul.
I'm happy that my made for radio mug doesn't necessarily get seen, but we lose without you.
I even put lipstick on for this occasion.
anything I say there would get me in trouble either way. So let's move on. Rhoda.
We'll move on. Okay, back to the serious part.
So default notices are really important because
Yeah.
there's two obligations under the legislation, isn't there?
Yes.
There's a property law obligation and a national credit code obligation.
Yes.
But do you see two notices usually?
No. Why not, Paul?
Because they're allowed to combine the two obligations into one big notice.
Yes. And that's in Queensland.
That is in Queensland, absolutely.
So again, there might be other obligations in other states. They might have an equivalent of a Property Law Act, and that's why, again, we say you really do want to get that advice from your own state if you're outside of Queensland. This only applies in Queensland.
Yep. And I was talking to one of the lawyers in South Australia the other day, and they do have a different form that applies.
Yes. So, yes.
So let's be really careful about that. Be aware, as we said there, you don't always need a default notice.
And why not?
Because there's some circumstances where the law's decided that it's important to either protect the property or protect the lender's interest when it's at risk. And the sort of things that apply there is if you can't find the person who owes the money, or in some rare cases, you might be worried that somebody isn't coping very well and might go and damage the property. And sadly, in the past, I think both you and I have dealt with people who, at the very least, have been threatening to do that.
Yes, and that's particularly the case. I mean, this is more likely to occur when we're talking not about real property, though. It's more likely to occur with cars and things like that, where there might be a real concern that the property will be disposed of. The other issue, though, is that not all the time, so once you've served the default notice, not all the times will you need to take legal action to repossess.
Yeah.
Do you know? What are those times, Paul? Or can I tell you some of them?
Well, the classic one that I'm going to start with is there's a high percentage of people that when they get a default notice will walk into their lender and give up the keys.
Yes, and that's perfectly okay. Then there doesn't have to be a court process because they have in fact already got possession of the property.
And we see lenders who don't understand this, Loretta, don't we?
I do think that, but I also think that lenders may still try and follow the process simply because they want to ensure that if later on it's challenged, they can show that they've gone through the legal process. I wonder if that's the case, because it's often struck me that in a lot of cases, they didn't need to take repossession action. The clients were quite willing to move out. But I think it's sometimes about protecting their interests.
I also think it's sometimes that lenders and lawyers generally, and I'm guilty of this on occasion, get very process orientated.
Yes, and we want to follow that.
And if something doesn't quite fit the process, they don't quite know what to do.
And this is especially the case if it's vacant land.
Yes.
Because for vacant land, all you have to do is put a sign or something on the vacant land and you've taken possession of it. You don't need to go through a court process. And I think that's not very well understood, particularly for clients, that the lender doesn't have to take legal action to take possession.
And it's something we see often in regional Queensland on the outskirts of some of our major regional towns. There are areas which are not necessarily serviced by the usual facilities, and there's just a vacant block that people might have a caravan on.
Yes. So all they have to do is
or there might be nothing on there, and all they've got to do is put a sign.
Yeah. So think, have a real think about that. The other thing, though, that the notices have to disclose is that there might be a shortfall. That there's a right to hardship and external dispute resolution, and that a subsequent default of the same kind in the period will not, and you pay one, but another default occurs, will not mean that they have to reissue the default notice. And the final thing is that it does warn them in that default notice about credit reporting. So have a look the next time your clients give you a default notice, where that covers off on all those things. I think they're pretty much getting
They're
there.
mostly pretty good, is my experience, but it never hurts to check. The next stage, though, is what tends to really freak clients out.
Is that they get served with a claim. Now, I just wanted to digress just a little bit, because in Queensland there are two ways of starting the proceedings can be commenced. One is by claim, which is the process that we're going to spend the time on, and the other is by application. And I've seen this maybe 3 or 4 times in the years that I've been practicing. So what happens is that a lender will put in an application into court seeking possession of the property. They support it by an affidavit, and they ask for a hearing date, and they only have to give the borrower 3 clear days service notice. So we've had a couple of those, including some dodgy lenders, what I would consider to be dodgy lenders, but we've also had some lenders who were not operating outside of the code, who were actually regulated by the code and commencing these proceedings by application. And we have had to step in very quickly because you don't have much time.
Second holders of second mortgages are probably more common in my experience doing it by application.
Yeah, well, I mean, the ones that I've seen, they were actually the primary lenders.
Okay, interesting.
So
I guess the other question, just before we dive into this, is are there circumstances where we think it's probably not a bad thing that clients have a claim issued against them? And one of those times, I think, where there's probably no other options is if they've been a survivor of family and domestic violence, and the perpetrator of the violence is in the property and saying, I'm going to stay in here until the police comes to forcibly remove me. Or
the case where the other party really needs the property sold, and the person is refusing to
even engage.
Because as a preference, we would always like the borrowers, if there is no possibility of salvaging the situation, that we'd like them to sell the property themselves, but sometimes it's just
not possible.
Exactly. So so what actually happens is that the lender files the claim and the statement of claim seeking possession. Then the next step, and when it's filed, that's when it's stamped with a date. And the claim is then served, and you have 28 days to file a defence. But when does that 28 days run from?
Many of our clients think it runs from the date of the stamp letter, but that's not right, is it?
No, because sometimes they can be 8 months
later,
down the track. So it needs to be from 28 days from the date of service. So it's very important to find out from the clients when they were actually served, because otherwise you might think, oh, it's too late to do anything about this. It's the time's already gone. We can't do anything about it. So
and just a reminder to feed questions through as they come to you.
Yes, they come to you. So I think that's one of the most important things to go and look for. One of the other things that you can do is if you're worried that the client's been served with a claim, I do an e-court search, and it will show if there's been a claim filed. It will also show whether there's been a judgment filed, so you know where the client is in the process. Because again, this is where you can take some action to help their clients, because if they've been served with a claim, what would be our normal response?
It would be get it into AFCA to protect your rights, is often what I'd be saying.
Even if you think at that stage you're not sure, like if It depends on the amount of time you've got, because if it's the day before the 28 days are up, or the days have already expired and the lender hasn't got a judgment, it's urgent. You must get that complaint.
Must get that person legal advice, and at the same time
into
AFCA, which for those of you if you're new is the Australian Financial Complaints Authority.
Yes, and because most of these lenders will be a member of that scheme.
Absolutely.
So it would only be those cases where you've been served with a claim that the lender is not regulated by the National Credit Code, that they would not have to. You couldn't
go to AFCA.
And then that's why it's so important to get legal advice, because you
need
don't
to work out
know
what you can
these
do.
things. Yeah, exactly. I mean, it's
the other thing that goes wrong at this point, Loretta, and you and I have both had clients like this, they get a lot of mail. Who do they get a lot of mail from?
Okay, so at this time, what you have to be really careful about, we've had some questions, but we'll look at that in a minute. One of the other things at this time, they get a lot of mail from those people seeking to help them stop their
house being sold.
Yes. And in one particular case that I saw at the start of the year, I think he had something like 23 letters, emails, and phone calls asking him to engage with these services. And as you know, the services often say, well, stop the repossession for a period of time. 60 days is very common.
It's pretty standard, yep.
And if they get it into AFCA, it will stop the repossession, especially if you're looking for hardship. And people are paying thousands.
8 to 10 grand, we said, haven't we?
Yes.
And just a reminder for all of us, how much does it cost to lodge a complaint in AFCA, right?
I thought it was free.
Yeah.
Am I?
Yeah. So these companies are making money off people's misery and charging them for something that they can access for free. And that's why it's so important you guys get them into AFCA before these guys get involved.
Look, the question that we've been asked is that very question of when might it be a good idea to have the claim filed. We can't force the lender to act, but one of the things that we have said is that the person who is wanting the property sold, and if there's a default, you can only do this if there's a default. If the other party is making payments,
there's nothing you can do.
Except through the family court process.
That's right.
But you can't use this process. But what we tend to say is that the person, either the wife or the husband, contacts their lender and says that they want the property sold, and that they can't get an agreement from the other party, and that they're not interested in a hardship arrangement. The problem is, though, that the other party could ask for a hardship arrangement, and the lender could give them that hardship arrangement.
Absolutely.
So and sometimes that can work to the benefit of our DV clients, because the ex-partner might very well be saying, we want that property sold, and the DV client is in the property with children, and we really do.
They need them to stay.
They need them to stay, and we do want them to be able to stay there until the family law proceedings are resolved, which might very well see them stay in the property for a longer period of time.
The other thing, Loretta, that's probably worth mentioning at this point is a reminder to everybody that the Australian Bankers Association has a specific guideline about family and domestic violence, which contains a lot of really good things that are not necessarily in the law that the member banks of the Australian Bankers Association have agreed to do to help people in just such a circumstance that we're talking about.
Excellent. And look, and on top of that, the Australian Financial Complaints Authority also has their approach to matters involving domestic violence, and I'd encourage you to read that. So Thanks for the e-court search. Just look up Courts Queensland, and then what you need to do, so just going to the Queensland Court website and then just look up
there's a tick box that says search civil files, and if you click on that link, it takes you straight to the search. All right, so moving to the next part, Loretta, what happens if our clients don't come to us or don't come to a financial counsellor or community worker until later in the process?
And there's been a default judgment. So if there's been a default judgment, the default judgment from our perspective is extraordinarily bad for the clients.
Absolutely.
If they haven't had advice before, because it's really narrowed the options that that client might have. So if we can get the person into AFCA before then, we might be able to organise time to pay, a hardship, time to sell. Once there's a default judgment, where I can't swear on this, so I'm going to where
we are up the creek without a paddle. Right?
Oh, that's a good expression. I was thinking of something a bit more colourful, but
for our G-rated time slot, let's go with that.
That's Thank you, Paul. Thank you. So what a lender can get default judgment. So if your client served with let's track back a bit. If your client is served with a claim and statement of claim, in a sense, they have two choices. They can make a complaint to AFCA, or they can defend the action. And by defending the action, they would have to put in a defence and a notice of intention to defend. It's quite a legalistic document, and that's why we say if you've got the access to AFCA, which is free and has no consequences, you would always go to AFCA as a preference than going through the court process.
But you should still get the client legal advice about their whole situation, even if you've lodged a complaint in AFCA.
Absolutely, because we can talk to them about what the consequences are if this doesn't go through and what will happen as a process. But let's just say they haven't come to you, they haven't put in a defence, they come to you and there's already been a default judgment. A default judgment is only available to the lender if no defence has been filed. And they don't have to give any notice to the borrower that they're
going to go and get it.
And so often what we get is, I was waiting to go to court. And so it's really important for us to tell clients that in fact there's no requirement for them to advise you that they're going.
The first thing you're going to get is a notice saying we have a judgment, you have X number of days to leave.
To pay or leave. And so no defence is filed, the 28 days have passed, the lender can apply for default judgment. They can do that online. So they don't have to give any notice. And then what the lender does, once that judgment issues, they serve that judgment on the borrower asking for vacant possession. They have to give them a minimum of 7 days. I haven't seen any clients really get that notice and pay out the money or
decide to leave. Doesn't happen very often.
All right, so what can you do though? Maybe let's just go back. What can the client do
at that point,
at that time, in terms of, we've got some of this after repossession. We might leave it. All right. So,
but it's worth saying just briefly that an option for the client to pay a judgment is saying to the lender, I want to sell my house.
Except they don't have to accept that, but we can.
We can ask the question at least. But let's come to that later on.
So so what the next process would be, or your client hasn't got out of the house. So what happens? Because I'm been talking to you.
Eventually, and there's no set time with this. Eventually, a lender gets cranky with the fact that they haven't left the house, and they'll give them time. And if they don't comply with that, they'll go back to court and say, "Can we have a warrant for possession of the house?" And what that allows them to do is give that notice to the bailiff. In other states, it's called a sheriff.
Yeah.
And the bailiff will go knocking on that client's door and say, serving you with this warrant, if you're not out of the property by this date, we will be coming back to physically remove you and your property from the house.
Yeah. So that's not.
That's highly stressful.
I must say though, there's a couple of things that I would say about this. Rarely do these warrants get served over Christmas. So we usually see a flurry of them if they're going to happen in December. It's rare to see the bailiff give less than 2 weeks notice. And it's likely to be longer over that Christmas period.
And I will often see 4 weeks.
Yeah. And it's sometimes possible to negotiate an extension of time, both with the bailiff and the lender.
Well, because the bailiff's acting on the lender's instructions.
Exactly.
So the bailiff, even if you ask the bailiff will say something like, I have to go back and check that with the lender.
Yes. So, but they're usually...
They're pretty good as a general rule.
Yeah. And the bailiffs, we have had bailiffs actually recommend to people that they seek legal advice,
which we thought was excellent.
Yes. So, and then the next process is eviction.
Yeah.
So then you have the person refusing.
They come with the bailiff comes with the police. You're removed. The bit people don't understand, I don't think, Loretta, is what happens to their goods that are still in the house.
Well, they get stored. So what actually happens is that the lender will get somebody in to pack up all the goods.
Yep.
And they don't care. Like I heard of an example where they simply leave all the food in the fridge and take it out. It gets stored. The problem is if you want to get those goods back, you have to pay
the storage costs.
The storage costs and the removal costs.
Yep.
And, you know, we've had cases where parents have rung us because they don't have any shoes for their kids because they've all been packed up and stored away. So the advice that we give if we get to this stage, and we'll talk a little bit about what people can do to avoid all these and what you can do, but let's just say we can't do anything. The advice that we give to people if they're about to be evicted is at least get your goods out of the property, or know that you need to get these goods out that are critical for you to live on a day-to-day basis. And sometimes that's not possible.
So the questions come through, and this is a good question, Loretta, is some people with judgments against them are still in the property 12 months later.
I've had them for 6 years.
Yep.
So often what happens is that the lender is not required to act on the judgment as such, even on the serving of the claim originally. Claims are fresh for 12 months.
Yep.
So up to 12 months, the lender doesn't have to go back to refresh the claim.
And sometimes they're using this process to put the fear of God in clients to get them to talk to it.
And sometimes that's why you have to be careful. If you know that there was a claim and you've entered into some arrangement, you want to make sure that the claim is discontinued. Because otherwise, if your client then collapses, then you've got to.
And it's the same issue with paying after a judgment, isn't it?
Absolutely. So I've run a few cases where in one case the person had been paying for 6 years post judgment, and then there was a problem, and the lender sought to get
enforce on the
judgment. So where you have an arrangement that's post judgment, one of the things that if you negotiate an arrangement, I usually ask that after 12 months, if the person has managed to make payments, that there's an agreement that the judgment will be set aside and then the claim discontinued. Because otherwise you have the situation where 6 years later, they could be coming after you. And in one of the particular cases that I have got some legal advice about this. It's going to be very difficult to set aside a judgment after 6 years.
Absolutely.
So unless you can, and it's quite a technical argument, and we haven't really found it. There are some case law about this, but it's very difficult. So if you know of clients that are in the property 12 months later paying, the negotiation that you want to have with the lender is, at what stage are you going to set aside a judgment?
Absolutely.
And discontinue the client.
And this process we're talking about applies similarly to, say, if it's a body corporate that's suing the client.
Except it depends. The body corporate, they don't have a mortgage over the property. So their path to enforcement is slightly different. However, the basic things
and the basic court process that they have to follow is exactly the same.
But it's at that stage of enforcement, so it's not that it's often that they can't get possession. They might get a warrant to sell the property, and that can be even more devastating than actually being removed because of some of the requirements around sale.
Different process for local councils.
Absolutely. Local councils have a different process as well.
And given how complicated that is, we might leave that one for another day.
Well, I'm just thinking body corporate repossessions, a body corporate enforcement and councils might be something that we can do at a different webinar and weave this in, because it's quite complex and we're ready.
We're behind time already.
Of course, because I like to talk.
All right, so let's think about after repossession. We've talked a little bit about that. The thing we probably should reinforce is, let's say the house does get sold. If it doesn't pay out the mortgage, the lender's mortgage, there's a shortfall. The person remains liable for that. If they have lender's mortgage insurance, I don't think I've yet encountered a client who understood when they got lender's mortgage insurance that that's not for the benefit of the client.
Absolutely not. I don't know why they call it mortgage insurance, because I'd like the name to be changed to loan risk fee, because it really is a fee that the bank pays to an insurer for them to give that loan to the person, and it covers them if they don't get all their money back. It still leaves the client liable for the shortfall. And I know why they market it like this, because if a client's paying $10,000 for this fee, they wouldn't be bloody happy. But if they think it's insurance that covers them, they go, oh yeah, well, you know, that's fair enough.
And I should say there is a lot of work being done by consumer lawyers in this space around improving how lender's mortgage insurance is explained to people, because at the moment it's not up to scratch.
So basically, mortgage lenders insurance is just insurance covering the bank. It doesn't help our clients at all, and they can be pursued years and years later. They may not hear from the bank again. So that's why you don't want to. You can't rely on mortgage lenders insurance.
Absolutely.
So we've got stopping repossession after judgment. I think we go after judgment and then before judgment. So after judgment, do you want to talk to some of these?
Let's talk about, you can, even if there's a court judgment, there is nothing stopping you having a negotiation with your bank and their lawyers. The thing to be aware of, though, is the bank doesn't have to do anything you ask. A lot of clients have the impression that just because they ask for something, the bank has to say yes. And the answer is they don't. Even if what's being proposed is reasonable.
And I must say, there's been two matters where there's been a very long time post-judgment where I knew that it was going to be very difficult to set aside, but the circumstances surrounding the loans and the length of time that these people have been paying meant that it was worthwhile making those submissions. And depending on how you do it, you can be successful, but it doesn't mean that the lender has to do it. To your point, So I had that one where there was 6 years. We managed to get an outcome without without going to court. Similarly, in another matter where the person had been paying, I don't know, and the loan was very small.
Yeah.
So we didn't need to.
The second option we've got there is about paying out the loan. The reality is, by this stage, unless somebody's had a rich aunt die, the only way this happens is by selling the property yourself.
Yes.
And if somebody's contemplating this, there are clients you'll have that think this is a way of buying themselves time. That's not what this is about. For the lender to treat you seriously, what we recommend you need to give them is a letter from the real estate agent saying that they're willing to act. And that letter should also say that in the real estate's experience, similar properties have taken X number of days to sell and they've sold for an average at X amount. Because what you're trying to do is make sure that you've given the bank a clue that you're actually serious about selling it yourself, because they get plenty of people who ask for this and they're not very serious.
I always think it's so important to give timelines,
Yep.
just to go, this is really important what you, this is, they just want to know that if this doesn't work, you're going to be out.
Yeah.
Basically.
Which is fair enough.
Now,
it's going to be rare for number 3 where somebody has a good case to set the judgment aside.
And I'll tell you why. I did run a case years ago, and I thought it was the best case ever. The person involved, and this is a decided decision, so it's fine to talk about
it.
But the person involved really had not seen their claim, had hidden all the letters behind they'd all fallen behind her couch. So the really typical example. But she was looking after an elderly mother. She had a child with a disability and another one with a mental illness. She was working part-time. She had so much stuff going on, but she had the capacity to repay. She just needed time to repay. So I went off to court going, because what you have to be able to show is not only, you have to be able to show 2 things, right,
yes,
to set aside the judgment.
One is the ability to pay, but there's problems before that, isn't
there? Well,
there?
no. One is that that there was some irregularity.
Yes.
Thank you, Paul. In the service of the process.
Yep.
And then second of all, that you have a defence.
Yes.
Now that is, a defence can very well be, well, I should have been entitled to a hardship variation, which is I can pay. And in the particular case that I had, the person could actually pay the arrears by making a claim on the, getting, what is the home loan assistance that you can get in Queensland?
It's a mortgage relief loan.
The mortgage relief loan in Queensland. So they were able to access the mortgage relief loan. And we only went to court, not on setting aside the judgment. We actually went to court to stay the enforcement. So it's actually a little bit false, because if it's post-judgment and they've already got that enforcement warrant, the first step that you have to take is to stay the enforcement. So we were only just got in really with staying the enforcement, even though we had so many factors which I thought made this a very good case to run. But it shows you how good your client's case has to be before you to get even a stay. And then you have to still have the ability to set aside the judgment.
Yep. And the other thing to remember is, even if you're successful, you generally have to pay the costs of the lender.
Yes, for setting aside the judgment, because especially if you were served with the proceedings. In that particular case, we did get the stay and we started to put together, and I think we might have even filed then the setting aside application.
Yep.
And it was at that stage we were able to negotiate a settlement. But I made sure in that settlement that at the end of the year, if that person was maintaining their payments, that the judgment would be set aside by agreement, and the claim discontinued. And that's exactly what happened, because otherwise, in a year's time, if we just disappeared, we got that settlement,
Yep.
and the client defaulted or started to have problems again, they could simply move to the same process.
Now, the last one on that screen, we've already talked about, Loretta, in the idea that you can always go to AFCA to try and seek a negotiated settlement.
Except,
Unless.
But we do need to be careful about this, because it's not, they will not necessarily allow people to then do hardship variations.
No, they won't.
So all they really do is to, in a sense, give you time to sell.
Yep.
Or negotiate or start the proceedings. So, yes.
Now, quickly, keep sending in questions through, because we're getting good questions, aren't we, Loretta? So
we're really getting
please keep sending those through. The other thing to remember that's important to talk about is if we can stop this process, it's usually to the benefit of the client.
Yes. So this is before repossession. We can do a lot here.
Absolutely.
So
let's talk about it. So you've mentioned state government mortgage relief already.
And that's only available in Queensland.
It's worth checking in other states what process is available, if any, with your state governments, because I am aware some other states do have similar type ideas. Obviously, seeking hardship is a big one. The thing about seeking hardship, though, is under the law, let's just say you've got a mortgage of 400 grand, your payments are 1,200 a week or a fortnight.
Yeah.
And you've had a sudden illness that means you're not going to be able to work again. Seeking an arrangement where you pay $200 a fortnight until the loan's paid off, because that's all you can afford, that's not likely to get up.
It has to be. I always say to clients, it's two limbs.
Yep.
Clients are always very passionate about how they're in hardship. And I always say to them, hardship has two limbs. The first limb is very easy to get over. So saying that all of their stories, of course, they're in hardship. But the second thing you always have to show is that if the hardship is provided, you will be able to meet your obligations under the contract in full. That does not mean with a reduction in interest. That does not mean with no interest. That does not mean that you can spend the next 100 years paying off the loan.
Absolutely.
It needs to be a balance. So, but it might include selling the property.
Could include selling the property. The question that's come through is around, has any of this process changed as a result of COVID hardship? I am aware, and it's worth talking about, that the Commonwealth Bank has come out and said, we are not going to force the sale of anybody's property until September 2021, which I think is a great initiative. My one concern about it is what they haven't said is what will happen to any shortfall that might accrue between now and September 2021 as people find themselves struggling to pay.
Absolutely, and I think that's one of the issues about the COVID response. Even though the banks have been really good on the COVID response, and we did have a slide about this. One of the big issues is, of course, that they've given all these moratoriums, but they haven't stopped the interest from running. And in fact, people's positions have worsened, could worsen, because if they're now sold, they could have a large shortfall. And if they're not sold until 2021, of course, that shortfall is likely to be more higher. And also it eats into the equity of their property. Now, it's not such a bad situation at the moment because interest rates are quite relatively low.
And one of the conditions of the AFCA relief that allowed the banks to do all these moratoriums was that the interest had to be placed at the end of the loan and the loan extended. So some of that problem is mitigated, but it doesn't get around the problem that people are still really struggling to pay.
Yeah, absolutely. So we talked about, so one of the other things that you can do, state government mortgage relief, but that has quite tight
criteria.
So in Queensland, it has to be for less than 20,000. So
and of course, accessing your super might be an option if you're suffering total and permanent disability. You might have insurance under the loan that you can claim against, which is pretty important.
I did have somebody claim on their consumer credit insurance successfully.
Good heavens, that's a rare beast, Loretta.
Yes, I spoke to someone the other day, so it can happen. Always good to check if people actually have insurance that they haven't claimed on.
And the final one that's worth talking about, I think, is that the earlier you get legal advice about your rights in this space, the better. Because not only is this a financial process, it's also a legal one. And so dealing with both at the same time is really important.
Yeah, so, well, that's the thing, because if we're seeking to stop repossession before judgment, we can ask AFCA to have a look at issues of liability, like should the person have got this loan, is the amount that they're being required to pay appropriate, those sorts of things. You can't do that post-judgment through the AFCA process.
Now, we talked a little bit about the COVID response already.
Yes, but there was a question, wasn't there? Was that a question?
Well, the question was about the AFCA relief, which I'd mentioned just before, around the idea that it's been placed at the end of the loan. And if you've heard that, that's exactly right. So we're nearing the end of the webinar. So if there's any other burning questions that you wanted answered during the course of this that we haven't covered, now's the time to send those through as we're going through these final slides. So as we covered earlier, Loretta, AFCA's got a lot of great resources around financial difficulty, how mortgagee sales should be handled, joint facilities and family violence.
Can I just make a little bit of a comment about mortgagee sales? Because
Absolutely.
one of the things that often comes to us, and this is why we encourage people to sell by themselves.
Yeah.
Because one of the things that often comes to us is that the lender sold the property for undervalue.
Yeah.
And the general rule is this, from my perspective: if it's within 20% of what you would have been able to get if you'd sold it yourself.
The key question though, if you'd sold it yourself at the same time.
Yes. If it's within 20%, I don't think that you're going to get up a case of saying that the contract is, that the mortgagee sale was not appropriate.
Yeah.
And there's been some cases about this, some legal cases. The case that, there was a case where the mortgagee sale was not found to be legitimate, and that was when it was, I think, 40% less than what the property could have been sold for. So if it's in that realm of less than 20%, and that can be quite substantial, because if the property is worth 500,000, that's if they can sell that really for 410, and you'd be really hard pressed.
The other important question in this space that's worth talking about around mortgagee sales and sales generally is around what if the property's got a tenant?
Oh yes, because you have to give notices.
Yes, and there are specific notices you have to give to a tenant if you're seeking to repossess that property.
And that can often delay the repossession, which can
give more time. Absolutely. So that's a really important part of this. The tenant does have some rights, but they don't have rights to stay in the property if the property notices.
No, I think it's about 60 days they get.
That's my memory as well.
Yeah. So again, this is where state law is important, because in Queensland, I think they know that you require 60 days.
Now, the other question that comes through is around independent valuations. Lenders are required to get a value for the property, but remembering that value is going to change, that valuation is going to change depending on how it's sold. If it gets to a point where a bailiff is selling it by option, the valuation there, as you've already said, is going to be significantly less than if it's sold by the owners of the property before this process happens.
Yeah, especially with lenders. Look, I do think that there are some issues around valuations. The problem is, and I haven't really looked at this so quickly, but clearly, but I do find that there is a difference in the way that valuers value the property, depending on whether they're at the start of the process, about to give a loan, or whether the sale is going to be it's a forced sale. So this also causes problems because lenders often don't go under the valuation, but the valuation is often not what the person might have got with a real estate agent doing all this marketing.
Exactly.
So it's not, it's unlikely to be as clear cut as
many clients that come to us think it is.
Yes. All right. So I don't know if there were any other questions.
One final opportunity for questions, guys. The other thing I'll spruik at this point is when we end the webinar, there'll be a survey. That survey will have an opportunity to comment on how Loretta and I have tag teamed this morning, and which is really important to us because we're always trying to improve. And the other thing it gives you an opportunity to do is put comments around what other webinars you'd like. So if you've got hot button topics, and I think we've picked up body corporate and council repossessions as one of them.
Because there are some things that you can do, and I do really think that they're worth exploring, and even the repossession or enforcement processes generally in judgments and matters like that might be of interest. Okay. But again, it would be more interesting to our Queensland colleagues than our interstate colleagues.
But having said that, if you're interstate, what you should always do is ask your local legal service if they're willing to do a webinar on the specific state legislation.
Yeah.
Because I know most legislations do. Sorry, most states have people who are experts in this area.
So grounds for the defence, not that you would ever do this, Caroline, because you would always send them for legal advice, but the grounds for the defence are, do they owe the money? Or in our case, so we always run the argument that the defence is, well, we had a right to apply for hardship.
Yep.
But generally, when you're looking at defending an action for anything, you're looking at, do you have, is there, is this contract unfair?
Yep.
Is there any liability on the behalf of the borrower? But our biggest argument in setting aside judgments is usually around hardship.
Yeah, I think
generally,
right.
If people borrow money for a home loan
and they haven't paid it,
they owe. And this is, Caroline, you've actually raised a really good issue. A partial defence is not a complete defence.
Yep.
So even if you could argue, well, the amount should have been 350 and not 400,000, that's not going to get you enough to put in a defence.
Absolutely.
It might change the amount of the judgment, but it's not going to be enough to be a total defence. So that's another reason why we think hardship is one of the best defences, but you wouldn't do it unless you were at the end of that post-judgment, because before that you would always, if it's available, go to the Ombudsman, simply because you're not at risk of costs.
So finally, can I thank you all for your attendance and your questions? It's been wonderful. Can I just remind you, on our social media sites, we put a lot of this information up that's useful for clients, and make use of all the publications we have on our website, remembering there's the ability from that website to order any number of publications you like and get them sent out to you for free. So can I thank you for your involvement today, and we will end the webinar now.
Thank you.